Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello, I'm Natalia Angelini.
And I'm Mark Lahn.
Welcome to Hull on Estates. You're listening and watching episode number 657.
And today we'll be discussing the case of Kolic Estate, which is a 2022 BC case. And this case deals with the rule in Cherry and Boultbee, which relates to when an executor can set off against a debt owing to the estate by a beneficiary. So I'll begin by kind of going through the facts, and Natalia will chime in, and then we'll go into the decision here and some key takeaways for executors and estate trustees. So in this case, this was the estate of Violet Kolic, and I think it's interesting to note this was about a decade of ongoing litigation in this estate. So that obviously impacts the decision of the judge and how this panned out. So prior to this particular judgment, a judgment was issued against the deceased daughter, Mary Kolic, in the amount of $235,000. So she was one of the beneficiaries under the estate. And this judgment represented funds that Mary had taken from the estate prior to Violet's death. So the total value of the estate was approximately $409,000. So obviously the $235,000 was a pretty significant sum for Mary to have taken out of the estate. And the key issue in this case was that there was a specific piece of property which was devised to 3 of Violet's children. So it was a quarter to Mary, it was a 6 to her brother, to her daughter Angela, and 4/6 to her son Joseph. So Angela and Joseph both wanted the property to be sold rather than an in specie distribution. And Mary didn't want the property to be sold. She wanted it to go to her. And so that was what brought the estate trustee during litigation to court to essentially ask the court, what do we do? Do we have an in specie transfer of this property, or can we sell it, which is what they wanted to do.
Right, and it was interesting because Mary, she only had a 1/6 interest if an in specie distribution did proceed. So then there would be the tricky issue of, how does the estate get recovery of that debt?
Exactly. That was part of it. And there's lots of little details in this case too. The evidence showed that Barry didn't have the funds to actually purchase the other 5/6 of the property. So really the court viewed this entire situation with the lens that Mary was, just trying to further this litigation, which, as I mentioned, this was about 10 years of litigation. Mary had been appointed as a state trustee, as far as I know, and had been previously removed a few years earlier. So there was, obviously a lot of other details surrounding this case that informed the judge's decision here.
Right, and one of those, I think, important ones is that Mary was living in the property.
That's right.
Certainly informed her position, right?
Absolutely. Yeah, she was living in the property, and then I think, there was some comments about they weren't sure if she was still living there, but she had a lot of possessions there. So the ETDL was also making comments about, we need to remove all that stuff and do some renovations to really maximize the value for the beneficiaries. And that was part of, the reason why they were trying to get an order to sell the property.
Yeah.
So yeah, a few of the issues, obviously, can the property be sold, or should an in specie distribution be made? And so the decision of the judge, they found that the sale of the property should be done. A lot of the arguments were focused on the interpretation of the will and the administration provisions. but the judge actually relied on the rule in Cherry and Boultbee to factor in the fact that Mary, owed this judgment debt against the estate. So
right, that rule is really that where a legatee has a share of the residue and is a debtor of the estate, you can't receive your legacy without bringing that debt into account, right? That's the gut of the rule, the guts of the rule.
Absolutely. Yeah. So it's an equitable principle designed to ensure fairness, as you said, when a legatee has a debt. And I think something that's really interesting about this rule is that it can be a statute barred debt. And that's obviously not something that's, something that you'd think you'd be able to enforce, a debt that's beyond a limitation period. But that's exactly what the rule holds.
Yeah, that was a really interesting point in the case, because the judge refers to a Supreme Court of Canada decision from the late 60s called Canada Trust Company and Lloyd et al. And their directors had improperly withdrawn funds 43 years prior. And it was taken into account. So I thought that's kind of a cool point. I like that. I personally like that. It is really ultimately a fair thing to do.
Absolutely. And I think in this case, I don't believe the debt was statute barred. Obviously, it was throughout the proceeding that was one of the orders. But I think that's a really important key takeaway from this one. There was a few other comments the judge made. They commented, nothing is being retained by the representative and nothing is being set off, but rather the contributor is paid by what he is holding in his own hand. And there is limitations to the application of this rule. They said that the debt has to go to the root of the property. And in this case, they found that the judgment debt against the estate went to the root of whether Mary was entitled to this in specie distribution. And that permitted the sale of the property.
Right. And that judgment, that debt was arrived at through a prior proceeding, right? That Mary and there was another sibling who also was living there with her, and he had died during this whole situation, but they had brought a proceeding trying to vary the will, I believe.
I believe that's what had happened here.
And it was through that proceeding and a cross claim that this judgment was arrived at. So it certainly went to the root, as you say, of the issue.
Yeah, absolutely. And the court concluded executors could withhold payment of a specific bequest to a beneficiary until the estate's claim against the beneficiary was satisfied. And that's exactly what happened here. So, I thought there were a few kind of key takeaways from this. Obviously, one, as we discussed, I think the fact that statute bar debts could be encompassed by this is really important. It's something that lawyers and executors should consider when they're kind of gathering the whole picture of the estate. Are there any of these kind of lingering debts in the past where, previously you may have considered, that's kind of too old, it's out of scope, there's no point in trying to collect that. I think there should be some consideration to that.
Yeah, absolutely. It certainly reminds us to, not dismiss these historical debts that some parties may have. Obviously you've still got to meet the test otherwise, but it's certainly a good reminder. Yeah,
and some of the other things, it just goes to the conduct of all of the parties in the litigation. And I think, the fact that this was such a long-standing litigation obviously informs some of the outcomes here. So it's something to consider, obviously. Invoking this rule, I could imagine if it was for a small debt, you may be asking for more trouble than it's really worth, because I'm sure a beneficiary would object to it and it would land the parties in court. And you may have to have kind of a balancing act there to decide, is it really worth litigating over? In this case, it was a very large debt and it was part of the proceeding. So obviously it was worth it in this case.
Yeah, and no question that the conduct of what happened in those last 10 years aided the court in landing as it did, right, and deciding as it did. And it is just such a shame when you think about, yeah, it was a sizable debt, but the whole value of the estate itself was quite modest, right?
Yes, exactly. I was really surprised.
Yeah, so imagine the legal fees. I mean, it's just a shame. And also similarly a shame that, I sympathize too with Mary for not being able, to retain any share of that property too. It's really a shame for both sides. But I do I do think that it is a good application of the rule, and it's a case I'll be remembering.
Yeah, me as well. Okay, so Natalia, any other comments about this particular case?
No, I think we've covered it all, Mark. Thank you. It's certainly a case I'll be keeping in mind for the
Me as
future.
well.
So thank you to those of you who are listening and watching our podcast. This concludes our podcast. Until next time, I'm Natalia Angelini.
And I'm Mark Lahn.
Should you have any questions, please email us at info@hullandhull.com or contact us through our contact page on our website.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.